Hello, hello, hello. Boss Attorney Bree here. For those of you who are new to the stream, welcome. For those of you who are returning, welcome back to the stream. Today we are going to be talking about Jay-Z and Bill Cosby. So, if you guys have heard about any of those cases and you would like to know what's going on, we're going to actually break down the discussion in the Jay-Z case, and then we're just going to briefly talk about Bill Cosby to start off with. So just give me 1 second, as you guys know, in the beginning of each stream, for me to get my life together over here so that we can get everything up and running. If you are watching the live stream, go ahead and comment in the chat box where you are watching from. If you're watching on the replay, go ahead and comment down below where you're watching from. So, all right, we are almost all set here to get this going. And yes, we're ready. All right. So, sorry for that strange introduction there, but first we're going to be talking about the whole Bill Cosby situation. If you haven't heard, yesterday the Supreme Court decided that they're actually not going to rehear the Bill Cosby case. If you are not familiar with the Bill Cosby case, he was actually under prosecution for allegedly SAing a woman years ago and in his home. More around the time where he was peak famous, right? And now he's an old man. He went to jail for a couple of years, and they ended up releasing him about a year or two ago, under the effect that a prosecutor or a DA or someone told him that he will not be prosecuted for this alleged assault. And so that's how the case got dismissed. And so the prosecutors took it up to the Supreme Court, and they decided that they were not going to hear the case. They did not leave any comment on it. They just denied hearing the case. If you don't know, the Supreme Court is generally pretty backed up. So that would make sense why they wouldn't want to necessarily review the case. So ultimately, Bill Cosby is going to be a free man on that case. The double jeopardy probably applies so that they cannot bring this case again against him because he already had the case. Is probably, I don't know for sure if it was dismissed with prejudice, but if it is, then they cannot try him for this alleged assault in the future. Now, if there are other assaults that people are alleging, that's not necessarily from I think it was two particular victims. If it's not from them, then it is a potential that a case could be brought against him. So for now, he is a free man. If you guys are watching on the live, let me know if you can hear me. If you're watching on the replay, I guess I would know or not if you can hear me. So with all that being said, we are going to jump right into the case with Jay-Z. If you have been subscribed to me for a while, or if you just binge watched some of my videos, you might have seen my analysis on the Jay-Z case. If you don't know about the Jay-Z case, he was basically sued for a breach of contract under a fragrance contract, where they used his name on the Jay-Z Gold fragrance, and the company is Parlux. They sued Jay-Z claiming breach of contract, that he was not actually promoting this perfume, this cologne, in the way that they should have been promoting it. They filed the lawsuit. They lost ultimately, in the sense that Jay-Z did not have to pay the $68 million that they were requesting from him. Some of their causes of actions were granted, but it did not result in him actually paying any money to them. However, Jay-Z also had counterclaims saying that they stopped paying him in 2015, but they continued to sell the fragrance until 2017, and he did not see any of that money. So as the conclusion of the case, if you guys are just here popping in and you want to know what happened, Jay-Z ends up winning $4.5 million in back royalties that they need to pay him for using his name under the licensing agreement. But I actually have the decision from the court that we're going to go through today. And if you watched my video a couple of months ago, you would know that I kept saying, oh, if I had the contract, then we would know. this decision actually lists some of the relevant provisions in the contract. So we will see part of the contract, at least the part of the contract that the court decided mattered in deciding these actual causes of actions and counterclaims. So I'm going to pop right over to sharing my screen per usual. If you guys are on the live stream, let me know where you're from. And also let me know if you heard about this case with Jay-Z or if you heard about um, Bill Cosby's case as well. So I am going to go ahead and pop over on the screen. If you're watching this on the replay, feel free to comment below what you think about these cases before we really get deep into it. So boom, let's make it a little bigger so everyone can see because I am visually challenged and I don't know if you guys are too. So let's just kind of read the brief overcap of the case. Okay, guys? So plaintiffs appeal and defendants cross appeal from the order of the Supreme Court, New York County. And for those of you who do not know, the Supreme Court in New York is actually the lower level court. In California, it's the Superior Court. In other places, they call it the Superior Court. But usually, a Supreme Court is the highest court of that state. In New York, it's the opposite. It's the lowest court in that case. So this is actually in the appellate division. It's not all the way up to, I forget what they call their Supreme Court, but it's not Supreme Court. To their highest level of court, it is at the second level right now with this appeal. So New York County entered on or about November 16, 2020. I think that's a typo because it was last year, so it should be 2021, which granted in part and denied in part plaintiff's motion for partial summary judgment and defendant's motion for summary judgment to grant those aspects of defendant's motion seeking summary judgment on the portion of their counterclaim premised on plaintiff's failure to pay royalties. So basically, they didn't pay him for the right to use his name. That's why they're calling it royalties, because he basically licensed his name, Jay-Z, for them to use on the fragrance, which was Jay-Z Gold. And they were supposed to pay him royalties for licensing his name. I actually have a video coming out. It should come out on Friday talking about how you can make money off of your trademark. Jay-Z is Jay-Z's trademark. And so he licensed the right to use that name out to Parlux. So they have to pay him for, it seems like the way they had this agreement, for each product that they sell or by the profit that they make, right? So that is why they're saying paying royalties for using his trademark, basically. Dismissing plaintiff's fifth cause of action, breach of implied covenant of good faith and fair dealing, and dismissing so much of the second cause of action, breach of contract, as asserted against defendant Sean Carter, which is Jay-Z, based on Article 7 of the license agreement. Plaintiffs also appeal and defendant cross appeals from the supplemental order. Same court and justice entered on or about November 19th, 2020. Again, I believe this was in 2021 because that's when I did my video, which denied defendant's motion for entry of summary judgment on their counterclaim. And then it goes on to list the actual attorneys in the case. And so, guys, if you are watching on the live stream, let me know where you're from. Let me know if you heard about this case. And let me know if you think that Jay-Z should be $4.5 million richer. It was in the contract. They were supposed to pay them. So if the court found that they did not breach their contract in their way, which you will see in a second why they're saying that Jay-Z still deserves to be paid, even though Parlux is claiming that he did not perform his duties under the contract. You will see shortly why the court thinks that he did perform his duties under the contract. And we're going to kind of go over a little bit of the facts of the case to figure out what part of the contract that they're using, that they're saying is relevant, and any other things that we need under it. That didn't make any sense, but we're going to go over what the court used to determine why they think that Jay-Z should be paid under this contract, despite the fact that Parlux is claiming that he did not deliver under the contract. So the appeal and cross appeal arise from the parties' dispute relating to the development and promotion of a fragrance line involving defendant Carter, the Grammy Award-winning entertainment mogul, otherwise known as Jay-Z. On April 18, 2012, defendants entered into a license agreement with Non-Party Artistic Brand Development, LLC, which they're going to call artistic brands, for the development and promotion of the fragrance line and related products. The license agreement granted non-party artist brand the exclusive right to use the trademark Jay-Z. As I was just saying earlier, Jay-Z's name, Jay-Z, is actually his trademark. And so he's licensing the right to use his name on these, on these perfumes or colognes, whatever they might be. The trademark relates to Carter and his held S. Carter Enterprises LLC. Carter, the sole member and manager of SCE, which is thus S. Carter Enterprises. They're abbreviating it as SCE. Signed the license agreement on behalf of SCE. I don't know if I want to keep saying that. That's like hard to say. SCE. Additionally, Carter signed the license agreement in his personal capacity, but only with respect to sections 2C, DC, and 11E. Carter's execution of those three aspects of the license agreement in his personal capacity reflected his personal involvement in the development and promotion of the fragrances that would be associated with his considerable professional identity and brand. And so we're going to get down into the breakdown of what the court thinks about that. But I do kind of want to stop right there and explain, because if you've been watching my live streams for the past few weeks, we've been talking about LLCs and piercing the corporate veil. Here, Jay-Z has this LLC called S. Carter Enterprises. And what Parlux is trying to do is to go ahead and pierce the corporate veil. Let me know if I'm having any trouble with the internet connection. I keep getting a little Wi-Fi signal here. So let me know if you guys are getting glitches or not, but we're going to go through the stream as usual, and hopefully you guys can actually see me. So back to piercing the corporate veil. We've been talking about this in a couple of my streams, that your LLC does not always protect you. If you are operating outside the capacity of your LLC, then you can be personally liable. Remember, the point of having an LLC is to protect your personal assets. If you are acting in a personal capacity and claiming that you're acting under your LLC, then it's possible that you will be personally liable rather than your business just being liable. And this is what Parlux is trying to do here. They're saying, since Jay-Z signed under his regular name and not under the capacity of his actual organization, then he should be held personally liable for some of the breaches of contracts that occurred. However, the court's going to break down and let us know whether they think that he should be personally liable. So if you're interested in learning about that, please stay tuned. And so I just kind of wanted to break down that piercing the corporate veil, because I know a lot of people have questions about that. And when people start businesses, the first thing that people tell them to do is to start an LLC. You'll be protected personally. You won't be liable personally. But if you're acting outside of the scope of your LLC, you can be held liable personally. And so one of the ways that you can avoid doing this is going to be to, one, have your operating agreement, and two, go ahead and whenever you sign anything on behalf of your LLC, you should also be noting on behalf of my LLC, whatever your LLC's name is. So when Jay-Z signed, he should have signed Sean Carter on behalf of S. Carter Enterprises, LLC. But they're claiming that on these certain provisions, 2C, 2D, and 11E, that he did not do on behalf of Carter Enterprises. This could be Jay-Z's fault, or it could be the company's contract fault. Let me know if you guys are hearing like a little static. I don't know if it's just my earphones that's giving me the static, but yeah. On to the good stuff. So these are the provisions that the court decided was relevant in determining this case. And it's going to sound like a lot of legal jargon to you guys, but we're going to explain it later on. And as we go through it, if there's something that I feel like needs to be explained, I will. If there's something that I don't explain and you want it explained, go ahead and let me know. If you're watching on the live stream, if you're watching on the replay, go ahead and comment below if there was anything I didn't explain that you would have preferred for me to explain. So getting down into the relevant provisions of the contract. So Section 2B, in pertinent part, which they're saying that Jay-Z should be liable personally since he signed under his name. Artistic brand is contemporaneously herewith sublicensing the licensed mark to a subsidiary, a perfume Perfumania Holdings Inc., collectively Perfumania, subject to and on the same terms and conditions as set forth in the licensing agreement, pursuant to a sub-license agreement between Artistic Brand and Perfumania, dated on or dated as of even date herewith. The sub-license. Pursuant to the sub-license, Perfumania is inter alia guaranteeing to SCE and Carter the performance by Perfumania and Artistic Brand of all the terms, obligations, warranties, restrictions, payments, and conditions contained in the agreement, as though Perfumania were a party here too. So they license the right to use Jay-Z's name, and Perfumania is sub-licensing the right to use the name. So they're probably selling it. I think Perfumania is a store, so they're probably selling it within their store, and they also have the right to sell under Jay-Z's name. That's basically what this is saying. In essence of this licensing agreement, that Artistic Brands contemporaneously enter into the sub-license, and that Perfumania guarantees in writing to SCE the performance of Artistic Brand and Perfumania of all the terms, obligations, restrictions, warranties, payments, and conditions contained in this licensing agreement, and any exhibits or agreements incorporated by reference herein. Section 7C states in relevant part, again, this is one of the sections that they're saying that Jay-Z should be personally liable for. And my bad, I thought I was sharing my screen, but apparently I was not. We're back into the opinion by the court, not just me talking and reading, guys. So you guys can read along ahead, however you want to do it, okay? Throughout the term of the licensing agreement, SCE and Artistic Brands shall work together in good faith in deciding the types of articles of licensed products that Artistic Brand may manufacture, sell, and market, all subject to SCE's reasonable approval. So they're basically saying that they can produce more than one product, which was they already agreed on the Jay-Z Gold, which had been sold, but they can also agree to sell more things under the name during the term of this licensing agreement, but that Jay-Z has to approve it. Artistic Brands shall provide SCE with a product development plan for each line of all licensed products, which plan may include Artistic Brands' assessment of the market needs and competitive positioning, and such additional information as reasonably requested by SCE. So basically, Parlux will be in charge of deciding what's happening in the market and what will be beneficial to them making a perfume. Artistic Brand and SCE shall jointly establish product development calendars. So they should work together to develop the timeline on which these products should be put out, under which at appropriate agreed points throughout the development process of licensed products, Artistic Brands shall make available to SCE the concepts, materials, fabrications, if applicable, packaging, and other relevant contents of each line of all licensed products for SCE's prior written, so it has to be in writing, written approval as the concept, interpretation, workmanship, and quality, to assure that licensed products are consistent in quality with comparable prestige products such as those referred to in Section 7AI above, and with SCE's standing and reputation with the public, the parties shall make every reasonable effort to adhere to the product development calendars. And let's just go on into this next provision to kind of get all of what they're saying needs to be done under this section. For each new line of licensed product, other than items from prior lines to be continued, Artistic Brands shall prepare and deliver to SCE for its prior written approval product concepts and specifications for those licensed product that it proposes to include in such line in accordance with the approved product development plan. The various lines of licensed products shall be created from such initial concepts and specifications, which shall then be modified and developed cooperatively by SCE and Artistic Brand until SCE has approved in writing a line which, including items from prior lines to be continued, is consistent with approved product development plans. So basically what this is saying is that Jay-Z and Jay-Z's company and this Parlux was supposed to work together in order to develop not only the Jay-Z Gold perfume, but potentially other Jay-Z perfumes and whatever else Parlux may make under the name. They could have had different lines under the Jay-Z name, and they were supposed to work together to get dates together to approve the actual concept, the design, and all of those things. And they're saying that Jay-Z should be liable personally under these provisions because he signed it under his name only. Let me know what you guys think about that. We'll get further into detail of the fact if Parlux actually did these activities, what the court thinks about Jay-Z's liability under these activities. So let me know if you guys are watching here live what you think. And also let me know, I know some people have popped in and out. Let me know if you have ever heard of this case. So popping back over to screen share. And again, guys, let me know if you can hear me. I'm on a new mic today, so I want to make sure that you guys can actually hear me for next time that I stream. This is being recorded, so I'll know at the end of this. But for those of you watching live, please let me know if you can or cannot hear me or anything of that nature. Subparagraph 3 of Section 7C provides the specifics of the product development approval process between artistic brands and the sub-licensing. Okay, all decisions by SCE shall be subject to approval, timing, and other approval procedures that are set forth in 7A above, and any disapproval, any licensed product shall be made in SCE's reasonable discretion and shall be accompanied with an explanation and, if possible, a proposed solution or alternative design and concept. Should SCE fail to give its approval, SCE agrees to engage in good faith negotiations, which is going to be an issue a little later on, with artistic brands to solve whatever objections SCE may have after such negotiations conclude and an agreement is not reached. Then SCE's disapproval shall be final and binding. And shall not be subject to review in any proceeding. So Jay-Z basically has the final say. Whenever Parlux delivers a product to them, Jay-Z has to review it, or Jay-Z's company, we should say, has to review it. And they can have a little bit of back and forth, but at the ultimate decision is with Jay-Z. Section 11E states in relevant part, and I don't think this is one that they're saying that Jay-Z should be, oh yeah, they said Jay-Z should be personally liable under this provision as well. SCE undertakes at artistic brand's sole expense and subject to Carter's prior professional commitments at artistic brand's request to make Carter available at reasonable intervals and for reasonable periods, which shall involve at least 3 appearances in each sale year of the term, at least one of which shall take place in New York City for promotional tie-in serving to associate Carter with the licensed product. During the term in the territory, artistic brands shall also be entitled to non-exclusive use of Carter's approved likeness. And I'm just kind of going to skip over that because they're basically just saying kind of the same thing. That he should not unreasonably or withhold or delay the meetup dates. SCE shall make every reasonable effort in light of Carter's busy schedule and subject to Carter's prior professional commitments at the request of artistic brands and upon at least 20 business days written notice to arrange for Carter's cooperation for a reasonable number of publicity events which shall be included in Carter's obligations of 3 appearances discussed above. And so I just kind of want to pause on this. If you guys watched my previous pre-recorded video on this case, I kind of noted that I wanted the contract for this particular purpose. And this is what I meant in that video about it being unclear. They asked for 3 appearances a year, and then they made it subject to Jay-Z's schedule already. And then they had to at least give Jay-Z 20 days notice before they actually picked the date, and Jay-Z had to approve of it. I don't know if they submitted evidence that they were complying with this paragraph, but this gives Jay-Z a lot of authority in deciding whether he's going to attend these promotional events. if he already has something pre-scheduled and then here comes Parlux 20 days prior to that scheduled event saying, hey, can you attend on this day? And Jay-Z says no, he has the right to say no in that specific instance. So they should have made it a little bit more clear for him to kind of keep certain weeks of the year open for certain events, or at least schedule those events the year prior so that he has the dates for the year prior and he doesn't schedule anything on that date. So I'm sure they wanted to give him a little leeway. And I think this was beneficial to Jay-Z in the end because he had the right to say, hey, I'm not available on that day. And they can't blame him for that because this provision is so broad and protects Jay-Z. It doesn't really protect Parlux. So I think that's very interesting, the way that they decided to word that paragraph. But let's pop back into the opinion of the court. Section A and C of Article 12 specify various statements, reports, and plans that artistic brand and its sub-licensee were required to deliver to a defendant. Article 15 of the license agreement addressed defaults, identifying those conditions and occurrences that constituted an event of default, including plaintiff's failure to pay defendants any sum due under the license agreement and plaintiff failure to deliver full and accurate reports pursuant to any of the provisions of the license agreement by the prescribed due date, therefore, for which the other party had to serve on the defaulting party a default notice. So if they failed to deliver the reports to Jay-Z, then Jay-Z would have had to provide notice to Parlux that they were defaulting on the agreement. Section 18F contains the license agreement no waiver provision. It states that no waiver by either party, whether expressed or implied, of any provision of the license agreement or any breach of default thereof shall constitute a continuing waiver of such provision or of any other provision of this agreement. Basically just means like if they waive it once by technically not doing something, so they didn't give them written notice of the default that Parlux was committing, it doesn't mean that they can't do it later on, or doesn't mean that Jay-Z can't do it later on. Lastly, Section 20A of the license agreement set forth a number of conditions that had to be satisfied before the license agreement would be effective. Notably, contemporaneously with the execution of the license agreement, Perfumania was required to execute a sub-license agreement with Artistic Brand to issue SCE's warrant to purchase at a designated price, a specified quantity and quality of common stock in Perfumania, and to sign a particular letter assigning certain profits to SCE. Section B provides that defendant have a direct claim against Perfumania on guarantee of breaches of the licensing agreement. So they were basically Perfumania was supposed to enter into a separate agreement with Parlux in order to assign the profits to Jay-Z's company and in order to assign stock in Perfumania to Jay-Z's company. And so it looks like they may not have done that. We'll check a little bit later on into this situation, but they were supposed to do several things that the court is highlighting. Consistent with, let's pop back over, consistent with Section 20A, two other transactions occurred on April 18, 2012. In one transaction, Artistic Brand sublicensed its rights and obligations under the license to Plaintiff Parlux Fragrance, a subsidiary of Plaintiff Perfumania's holding. Parlux assumed all of Artistic Brand's obligations under the licensing agreement. The signatories to the sub-license agreement were, through their respective members or agents, Parlux, defendant, and Artistic Brands. In other transactions, Perfumania executed the assignment letter with SCE and Artistic Brands. Under the assignment letter, certain profits derived from the licensing of Jay-Z's trademark were assigned to SCE. Additionally, at some point, Perfumania provided Carter with approximately $2.8 million in common stock in the corporation, which was something that they were supposed to do under Section 20, if you guys recall. During the and then so we're going to pop on to the next part of the complaint. For those of you watching live, I've been trying to get someone to comment and let me know if you guys can hear me okay. So if you are there, please let me know if you can hear me. I'm having some issues with Wi-Fi and I am on a new mic. So let me know. If you're popping in a little bit late, we are talking about a lawsuit that Jay-Z had with a perfume company that helped him produce Jay-Z Gold, and the fact that they haven't paid him. And Jay-Z recently won on this lawsuit back in November 2021, which absolved him of having to pay $68 million to this Parlux company. But in this case, it was an appeal. It's looking like Jay-Z is going to be awarded money for Parlux's breach from paying him royalties. So that's where we're at as kind of a recap. But we're now I just went over all of the provisions of the actual contract that the court found important in this case. So we're going to pop down into the next section that were kind of the facts of the case that occurred after the contract. So now we're going to talk about what happened when they started selling things and who breached what and blah, 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 or what the different companies thought was a breach or not. All right. So during the 2013 holiday season, Parlux launched a product line called Gold Jay-Z, investing approximately $15 million to develop, manufacture, and promote this fragrance. Although the product launch was a success, was a success, with Gold Jay-Z representing Parlux's top-selling fragrance in the United States for a time. Plaintiffs were disappointed with the overall performance of Gold Jay-Z, as discussed below. Plaintiffs attribute the lackluster in their eyes sales performance of Gold Jay-Z to certain breaches of the licensing agreement by defendant relating to Carter's alleged failure to endorse and promote the fragrance in the manner required under the licensing agreement. Plaintiffs Parlux sought to release a flanker fragrance the following holiday season. The flanker fragrance was represented a new product line by Gold Jay-Z. It was never released. Gold Jay-Z itself remained the fragrance market generating sales. Plaintiffs had greater expectations for Jay-Z related flanker fragrance, but those expectations were not realized. So they intended to launch a different fragrance that never got approved by Jay-Z, so it never was released. They don't really give too much detail on if they ever presented Jay-Z with the marketing plan for this, which they would have been required to do. But this flanker fragrance was never released. The parties' relationship deteriorated throughout the first half of 2015. By July 2015, plaintiffs ceased making royalty payments to Jay-Z. And so if you were here in the beginning of the live stream, this is what I was talking about. Jay-Z is suing for royalties for the sales of the perfumes because they stopped paying him in 2015, but they continued to sell into 2017. He is saying that he's entitled to those royalties despite the breach of contract that Parlux is claiming that Jay-Z did, which I didn't realize that Parlux was a subsidiary of Perfumania until I got on the live stream. So, all right, popping back over to the case or the opinion in this matter. In January 2016, plaintiff commenced this action to, among other things, recover damages against defendant, asserting causes of action for breach of the license agreement and breach of the implied covenant of good faith and fair dealing. Plaintiff alleged that Carter refused to endorse and promote Gold Jay-Z in the manner required by Article 11 of the licensing agreement. Remember, this is where they said he was supposed to make 3 appearances in a year, but they left it so broad and at the discretion of Jay-Z of whether he would be at those appearances by not selecting the dates the year prior to give him notice and not give him the ability to say, no, I'm not going to go there. They needed to come up with dates that worked for both of them at the beginning of the year so that there could be no confusion of when these meetups were actually supposed to be. And that he frustrated the development of the flanker fragrance in a breach of Article 7 of the licensing agreement. Plaintiffs also allege that defendants' breach of the license agreement and the implied covenant of good faith and fair dealing resulted in millions of dollars in lost sales of the Gold Jay-Z and flanker fragrance products. I wonder if they're going to give us more detail about why they think or if Jay-Z didn't perform his duties in approving the flanker product. So let's see if they're going to give us more detail. Defendant served an answer containing, among other things, a counterclaim against plaintiff for breach of the license agreement and a counterclaim against Perfumania for breach of guarantee. Pursuant to a stipulation, defendants withdrew the aspect of their counterclaim for breach of the license agreement that was premised on plaintiff's alleged failure to provide defendant with various plans and reports, such as product development plans for flanker fragrance. Section C, quarterly and annual reports relating to product sales and promotional expenditures and annual business plans. Defendant counterclaim seeking damages for breach of license agreement was therefore limited to claims that plaintiff breached their contractual obligation to pay royalties and remit certain promotional spending shortfalls to defendant. Defendant's assertion that plaintiff failed to provide defendant with various plans and reports under Section 7C, 12A, 12C, an assertion they consistently pressed during litigation became, in effect, an unpleaded affirmative defense to plaintiff's counterclaim of breach of contract. So remember, as I was stating earlier, I was wondering if they were going to get into more detail regarding if they gave the plans and reports to Jay-Z and then Jay-Z just failed to approve them or failed to acknowledge them. But basically what this is saying here is that they withdrew their affirmative defense that, okay, Flinker didn't come out, but Parlux never gave us the reports. So they're saying that Jay-Z cannot claim, oh, I didn't have the reports, and that's what stopped Flinker from going out. That's what stopped Gold Jay-Z from being productive, is the fact that Parlux never gave me the report. I don't have like the details on why they withdrew that complaint, or not that complaint, but that affirmative defense. But apparently they came to some type of stipulation that they would not assert those defenses in this case. So that's what's going on there. Alrighty. So let's pop back over to the actual opinion. We are making our way through this. We are 30 minutes into the live stream and not halfway done with this opinion, but we're going to keep going. Plaintiff subsequently moved for summary judgment, dismissing, among other things, any affirmative defense by defendants that plaintiffs failed to provide plans and reports required under 7C, 12A, and C, and to preclude defendants from raising any such defense. Also, plaintiffs sought summary judgment, dismissing defendants' counterclaim against Perfumania for breach of guarantee. Defendants moved for summary judgment on their counterclaim, seeking damages for breaches of the licensing agreement and dismissal of plaintiff's complaint. So they're basically saying, like, this should not even be a case. Let's get rid of it. Jay-Z's team. In a thorough decision and order, Supreme Court, among other findings, denied those aspects of plaintiff motion seeking summary judgment, dismissing any affirmative defense that they failed to provide plans and reports required under Sections 7C, 12A, and 12C, and defendants' counterclaim against Perfumania for breach of guarantee. So they denied Perfumania's summary judgment motion, basically saying that Jay-Z should not be able to say that they were never provided the reports. So I don't know why they were saying that they came up with a stipulation and Jay-Z can't assert it, but the court said no, that's not how it's going to work today. In addressing the plans and reports provisions of the license agreement, Supreme Court rejected plaintiff's contention that defendant waived their rights to receive the relevant plans. Oh, sorry. Whatever. Moving on. Relevant plans and reports, and concluded that the product development plan called for by Section C was a condition precedent to defendants' contractual obligations to work in good faith with Parlux to develop the flanker fragrance. The court found that tribal issues of fact existed regarding whether Parlux satisfied this condition with respect to defendants' motion. And so that was what I would have decided. I thought that Parlux was asserting that there was some type of stipulation into why they couldn't assert this affirmative defense, but that affirmative defense is very important because they're saying the reason why Flinker didn't go out is because Jay-Z was not cooperating. But in order for Jay-Z to cooperate, they needed to give him the plan and the report for him to see and approve in writing. Remember, we talked about that earlier. If you missed that part, you can watch it on the replay of why they were required to tell Jay-Z what was going on. Otherwise, they can't blame him for the failure of the perfume going out because they never gave him any market plan. All right, so let's pop back into the opinion. With respect to defendants' motion, Supreme Court in effect granted them summary judgment on the issue of liability on the aspect of their counterclaim premised on plaintiff's failure to pay royalties required under Articles 8 and 9. The court observed that plaintiffs never terminated the license agreement, continuing to market and sell Jay-Z Gold Jay-Z until May of 2017. So they owe him about 2 years of royalties, or a year and a half of royalties, if they're counting from the end of 2015. Yet the court further observed plaintiff made no royalty payments after April 15th. Okay, so I spoke too soon. It's about 2 years of royalty payments that they owe. The court found, however, that plaintiffs could be entitled to set off against the amount they owe defendant in royalties if at trial plaintiffs prevailed on one or more of their causes of action against defendant. Supreme Court denied that aspect of defendant's motion seeking summary judgment, dismissing plaintiff's cause of action for breach of the license agreement, finding that various triable issues of fact existed as to plaintiffs' and defendant respective performances under Article 7 and 11. Lastly, the Supreme Court denied the aspect of defendant's motion seeking summary judgment, dismissing plaintiff's cause of action for breach of implied covenant of good faith and fair dealing, rejecting defendant's argument that the cause of action was duplicative of plaintiff's cause of action for breach of the licensing agreement, and as pleaded and litigated, sought to impose obligations that were inconsistent with the defendant's obligation under the licensing agreement. All of that just to say that they believe that there could be potentially an implied covenant of good faith and fair dealing, and it does not fall under the breach of the licensing agreement. In response to an inquiry from counsel seeking clarity regarding the court's determination of the aspect of the defendant's motion seeking summary judgment of their counterclaim, the court stated in a supplemental order that defendants were not entitled to enter judgment for the sum desired on the aspect of their counterclaim premised on plaintiff's failure to pay royalties. As expressed in the decision, plaintiffs may, depending on the outcome of the trial, be entitled to set off the amount owed for unpaid royalties. So basically, the court is saying that there are likely royalties owed to Jay-Z, but if the court finds that Jay-Z violated the contract in any way, they can kind of offset the cost. So let's say that Jay-Z is liable for $2 million for breach of contract, and what's owed to Jay-Z is $4.5 million, then basically what will be owed to Jay-Z will be 2.5 because they're offsetting the amount that Jay-Z owes them. So hopefully that makes sense. I think it does, but we're going to pop back over. Okay, on appeal, plaintiffs take issue with several aspects of the Supreme Court issue. First, the plaintiffs assert that the court should have granted that aspect of their motion seeking summary judgment, dismissing the affirmative defenses and failure to provide the report. Second, plaintiffs maintain that the court erred in concluding that under Section 7C of the license agreement, plaintiffs' provision to defendants of product development plans as a condition of precedent to defendants' performance. And so I'm just kind of speeding through this one right now because it's going to be readdressed in the argument section down below. Third, the plaintiffs take issue with the court's denial Third, plaintiffs take issue with the court's denial of that aspect of their motion seeking summary judgment, dismissing defendants' counterclaim against Perfumania. They want Perfumania to still be liable. Plaintiffs argue that Perfumania is not a guarantor of the performance of the license agreement because Perfumania is not a signatory to any document because, remember, they failed to execute the sub-licensing agreement that they were supposed to do under the contract with Jay-Z. For their part, defendants cross-appeal from the portions of the Supreme's decision an order that denied the aspect of their motion seeking summary judgment on their counterclaim for breach of license agreement, dismissal of plaintiff's cause of action for breach of license agreement, and dismissal of plaintiff's cause of for breach of implied covenant of good faith and fair dealings. Now we're going on to Jay-Z's team. Defendants argue that they are entitled to summary judgment on the counterclaim seeking damages for breach of the licensing agreement because plaintiffs breached the agreement by failing to make certain contractually mandated royalty payments and by failing to spend certain minimum amounts to promote Jay-Z products. Defendants assert that plaintiff cause of action for breach of license should be dismissed because defendant did not breach their obligations to promote Go Jay-Z or work with plaintiff to develop the fragrance or the flanker fragrance. Specifically, defendants insist that plaintiff knew or should have known that Carter would not be available on the promotional dates selected by plaintiff, and with respect to one of the dates, plaintiff failed to give defendant sufficient notice of the date. Defendants maintain that plaintiff's breach of license agreement claim against Carter, premised on Article 7, must be dismissed because he is not assigned a signatory to the article. Defendant contends that plaintiff's cause of action for breach of implied covenant of good faith must be dismissed because it is duplicative. So they're still making that argument. All right, so let's go down into the court's actual analysis on these issues. We're halfway through the document, but it's probably going to go a little faster because we're not going to read every single argument that they have going on in here. Let me know if you guys are understanding this case or if you're even interested in this case, if you're watching this on the replay or if you are here live. Let me know what you think of the case. And if you think that Jay-Z should be $4.5 million richer because of this breach of contract claim. All right, let's pop back over. Now I'm literal. Okay, with respect to the Supreme Court's denial on the aspect of plaintiff's motion, seek a summary judgment dismissing the affirmative defense alleging that they failed to provide plans and reports required under Section 7C, 12A, and 12C. We agree with plaintiff that none of the plans and report provisions presented an express condition precedent for defendant's obligation. Rather, the plans and reports provision represent contractual promises. However, triable issues of fact exist as to the extent plaintiffs breached their contractual promises to provide various plans and reports, and whether defendants elect to continue performance of the license agreement or waive some of those breaches. Preliminarily, among the various plans and reports provisions of the license agreement, only one was characterized by the Supreme Court as a condition precedent, the product development plan contained in Section C. Defendant agrees with the Supreme Court that it should be a precedent. The appellate court concludes that plaintiff's provision of a product development plan was not a condition precedent to defendant's obligation under 7C of the license agreement. And then it goes to give us the actual definition of what a condition precedent is under the law and what express provisions are, but we're not going to read that. Section C does not contain any traditional unmistakable form of conditional language. Examples will be unless and until or null and void, demonstrating that plaintiff's provision of the product development plan was an express condition. Defendant's obligation, rather, 7C uses the word commonly associated with contractual promises, the word shall. Moreover, Section 20A of the license agreement lists various conditions that the provision of the product development plan is not among them. Therefore, plaintiff's provision of Section C product development plan, like the provision of the other plans and reports required by Section 12A and C, is a contractual promise, not a condition. All right. And so we're going to kind of pop back over, and then so the court ultimately decided that the Supreme Court properly denied summary judgment dismissing plans and reports as an affirmative defense, and I kind of popped over that. Okay, so they're kind of just talking about if they waived the right to receive those plans and reports, and the court is finding that no, they didn't, or I don't know if they found no. Yeah, whatever. Okay. The license agreement, the sub-license agreement, and the assignment letter were executed almost simultaneously related to the same subject matter and are plainly part of the same interrelated transaction. Therefore, those documents must be read together. Oh, that is a law. Sorry, I skipped over. The Supreme Court also properly denied aspects of plaintiff's motion seeking summary judgment, dismissing defendant's counterclaim against Perfumania for breach of guarantee. It gives us the law that they followed, what will be considered a breach of guarantee. You got to read the documents, get it. And then here is their breakdown of it. The Perfumania, as used in the license agreement, refers to both Parlux and Perfumania, is reinforced later in 2B. Part of the guarantee provision of that section that it is the essence of this licensing agreement that artistic brand contemporaneously enter into the sub-license that Perfumania guarantees and write into SCE, the performance by artistic brands and Perfumania of all the terms, obligations, restrictions, and warranties, blah, 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 contained in the license agreement and any exhibits of the agreement incorporated by reference herein. If Perfumania was read to mean Parlux only, then Parlux would be charged with guaranteeing their own performance. That's absurd reading of Section 2. Section 2B avoided in that case. Because Perfumania is defined by Section B includes both plaintiffs, a natural, sensible view that the section of guarantee provision emerges. Perfumania guarantees performance by artistic brands and Parlux. And then they go on to say that there's further reinforcement of this. Perfumania signed the assignment letter as opposed to the sublicense, does not, in light of the content of various transactional documents above, pose the statute frauds of problems for defendant. All right. And then thus the Supreme Court properly denied the aspect of plaintiff's summary judgment motion seeking to dismiss defendant's counterclaim against Perfumania for breach of guarantee. So ultimately, the court is deciding that Perfumania is just as liable as Parlux. So basically, if Parlux cannot pay, then Perfumania will have to pay on their behalf or the remaining amount that they owe to Jay-Z. Boom, moving on. Did I go past it? Okay. Defendants are correct that they are entitled to summary judgment on the aspect of their counterclaim premised on plaintiff's failure to pay royalties required under Article 8 and 9 of the license agreement. The record is clear. Parlux sold licensed products after July 31st, 2015, but failed to pay royalties on those sales. Plaintiff's contention that no judgment on royalties counterclaim is warranted because defendant may have some liability to plaintiffs on the claim in the action is without merit. Simply put, there is no right to set off possible unliquidated liability against a liquidated claim that is due and payable. Thus, the defendants are entitled to summary judgment on their royalties counterclaim. This means that Jay-Z will be getting paid the royalties that he was owed under the contract. The Supreme Court correctly denied that aspect of defendant's motion seeking summary judgment, dismissing plaintiff's cause of action for breach of the license agreement. Defendant's contention that the plaintiff's breach of the license agreement bar plaintiff's damages claims is without merit. Defendants are, of course, correct that plaintiff's performance under the license agreement is an element of plaintiff's breach of the license agreement claim. However, neither plaintiff's breach of the royalty provisions of the license agreement nor their breach of their contractual duty to spend certain minimum amounts to promote Gold Jay-Z products or remit certain promotional spending shortfalls of defendant necessarily precludes their claims for defendants' alleged breaches of Section 7A and 11E. A material breach of license by plaintiff would afford defendants a choice to affirm the license agreement and continue with them or terminate the agreement and seek redress. But if a breach was not material or defendant elected to continue with the license agreement in the wake of a material breach, the license agreement remained in force and performance by defendant was not excused. Similarly, defendants were free to waive the right to treat a material breach by plaintiff as grounds for termination of the license agreement and continued with their agreement. Here, the extensive factual record demonstrates the existence of triable issues of fact with respect to whether defendant elected to affirm the license agreement after a material breach by plaintiffs or otherwise waive their right to treat it as a material breach. Okay, defendant's contention that a written request from plaintiffs at least 20 business days before a proposed appearance by Carter was an express condition their performance, blah, blah, blah. They go on to talk about how there is triable issues of fact with regard to the substance of plaintiff cause of action for breach of the license agreement. Triable issues of fact exist regarding whether defendants breach their obligations to promote Gold Jay-Z or work with plaintiff in good faith to develop fragrance, and whether defendant elected to continue the license agreement or otherwise waive the right to receive 20-day written notice under Section 11E. And to be honest with you guys, I don't know what the decision was there or what they were even arguing about there. And then I kind of already know what happens in this section because I looked at it earlier. It's basically talking about how Jay-Z is not going to be held personally liable because he signed under his regular name. But we can go ahead and go through it. They don't really go too much in detail regarding it. Defendants are entitled to summary judgment dismissing plaintiff's cause of action for alleging breach of implied covenant of good faith. The implied covenant of good faith and fair dealing embraces a pledge that neither party shall do anything that will have the effect or destroying or injuring the right to the other party to receive fruits of the contract. And by that, the court notes that to the defendants, to the extent defendants were entitled to exercise discretion in the manner in which they performed their obligations under Articles 7 and 11, they were under the covenant and by natural extension under the license agreement itself prohibited from acting arbitrarily, irrationally, and in bad faith. So they do get summary judgment on that aspect of it. And we are almost to the end of the case, so let's kind of get ready to wrap the live stream up. Defendant's appeal from the supplemental order is dismissed because the order was not the product of the motion of notice. Rather, supplemental order was issued in response to an inquiry from counsel seeking clarity regarding the court's decision and order determining summary judgment. So they're basically not going to dismiss that. And so with all that being said, the court did ultimately decide, I think what Jay-Z's company was truly looking for was the fact that Jay-Z is entitled to being paid royalties, which means he's going to get paid what the reports are reporting, $4.5 million in royalties of the Jay-Z gold fragrance that was sold for 2 years after they kind of stopped working together and after the promotion ceased. On the other hand, it looks like Parlux and Perfumania pretty much lost on all of their appeals, so could be considered a waste of money or whatever, but the court did not award cost. I believe they did not award cost in this case. Both parties are entitled to paying their own costs, if I'm not mistaken. Yep, without cost. So they will pay their own costs. They don't have to pay each other's costs. So I think that is a win for them. But ultimately, Jay-Z ended up winning his contract. Or not his contract, one of his appeals, which was the most important one, which was that he gets paid money for the royalty. So that is all with this case. If you guys have any questions, feel free to comment them down below. Be sure to like the video. I forgot to say that throughout the whole live stream, but go ahead and like the video if you found that informative. And if you agree with the court's decision that Jay-Z is entitled to getting this money. If you do not agree, make sure you comment below and let me know why you do not agree. I will catch you guys on the next live stream. All right.